We're recording.
Hello and welcome everyone to another evening of the Austin Python meetup. Today we're welcomed by Steve, our lawyer. What's your last name?
Steve Swernofsky.
Swernofsky. And he's gonna give us a fun little presentation of how to royally mess up your startup. Sorry if I took your title there, but
No problem.
take it away.
Okay, so this presentation, I'm Steve Swernofsky. Hi. Yes, I am a lawyer. Yeah, I even look like one, but I'm not your lawyer. I want to warn everybody about that. And this presentation is called 10 Ways to Royally Mess Up a Startup, or alternatively, we could call it FAFO, but with lawyers.
Can you just
How do I do that? Wait, here we go.
Yeah, I thought it was usually there. I am an engineer. I've made one PowerPoint this year and it clearly wasn't good enough.
Is it in the view menu on the right?
I guess that is slideshow.
Oh, here we go. View.
You could just, I think slideshow is what everyone just said.
Oh,
Slideshow.
slideshow.
And start from the beginning, yeah.
Start. There we go. How does that sound?
Does that do anything? Not really.
It-
Oh, there it is.
How many Python programs?
Start a slideshow.
You know the joke. How many software engineers does it take to change a light bulb?
And plus one?
None. That is a hardware problem. Okay, so 10 ways to royally mess up a startup, or FAFO, but with lawyers. Okay, so that's how you know you really FA'd and FO'd. Okay, so here we go. So I'm Steve Swernofsky here. This is me. This is the picture I have on LinkedIn. It's really cute, but one day I'll have a real photo. And you can actually use this QR code to actually contact me on LinkedIn if you want. I can come back to this slide or I can leave it up, your choice. And there's my email address, so I'm easy to find. All right? Say when. If I see cameras, I'm going to wait. It always gets to me when people put a QR code up on the screen. They go, blah, 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 flip. And then you go, wait, I wanted to copy that, but no. All right, so if we're all ready, we go to the next. Okay, so every lawyer has disclaimers. I have my standard disclaimer, which is, yes, I am a lawyer, but no, I am not your lawyer. So if you want to talk to me, feel free, but I'm not your lawyer. Okay, and this presentation is not legal advice. And if you want to talk about something which is like private to you and you do that in front of everybody, it's no longer private to you, so don't do that. Okay, hope this is clear. Everybody who's showing up remotely, read this slide. Okay, thank you. All right, so we're going to talk about how you can royally mess up your startup, and there are lots of ways to do it, but I'm going to go over things one by one, roughly. And one of the most important things that people fail to do when they start up startups is to get their ducks in a row. Okay, by the way, I did say earlier, please ask questions. I try to make these presentations interactive, because what I've discovered is that people have questions, and then I will run through and I can tell you a zillion things about how the law works, and you'll still not know what I'm talking about. All right, so ask. And even if you think this might be a silly question, or I'm going to take a while to answer it, or that I might not have a good answer, try anyway, because worst case scenario is I do what all lawyers do, and I will fall back on saying, it depends. Okay, which is like not an answer at all. Okay, so very commonly people start startups and they go, oh, we're going to start a startup, and they don't have anything clear in their head, or they have some things clear in their head, but not enough of them. You need to know who is going to be involved in your startup. Okay, typically people say, well, I'm going to have me, and I'm going to have so-and-so who's going to help me out, and then so-and-so might help me out. All right, you need to get this clear, because you need to know who is going to invest in your company, who is going to be a founder of your company and get founder shares, who is going to be what officer in your company and have what responsibilities. And people often fail to do this, and we do need to do that, because if you don't do it, at some point later in time, people change, the world, disagreements happen, the world falls apart, and then suddenly you have a messy situation. If you have your ducks in a row to start with, you don't have a messy situation later, or at least it's not messy because of me, all right? And if it's messy, it can be messy for, social and emotional reasons, but not for legal reasons, because legal reasons tend to cost you a lot of money. You need to know who's going to be a founder, who's going to be an investor, who's going to be an employee, who's going to be a contractor, what you're going to, of course, you need to know what you're doing. It's like, we're going to build XYZ and we're going to sell it to ABC. Great. But sometimes people have a good idea of that and they don't have a good idea of who is involved, who is important. All right. You do need to know what. Now, one of the things I'm going to focus on in this talk is intellectual property. So one of the things you do need to do is what you're building, what's special about it. Okay, if you're starting a startup, you're obviously not starting a startup to sell corn. You're doing something that's new, hopefully. Okay. Pardon me?
Seashells on the beach.
You're going to sell seashells on the beach. What's clever about your seashells? What's unique? What's different?
Nature, they're beautiful. They're all
Absolutely. And how are you going to beat every other seashell seller on the beach? So notice how I said seashell seller and I did not mess that up? Okay. Yes.
So, it seems like 99% of startups at the beginning, they think they're doing one thing and then later they realize, no, that's not what they're doing.
Makes sense.
So, I guess it could be useful to decide what you're doing, but I'm wondering why that's important when you're almost certainly going to change your mind later.
It's fine if you're going to change your mind, because changing your mind is okay, but changing your mind from A to B is a lot easier than changing your mind from vague, fuzzy nothing to B. All right. And I'm going to be going over in detail some of the what issues. And some of the what issues are, well, we're going to sell seashells on the beach, and our seashell sales portal is going to use blah, 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 this clever new technique, and naturally there'll be an AI play for selling these seashells on the beach. Okay. And we're going to do it differently in the way of X. Okay. And then maybe you don't want people to know what X is. All right. Well, if you don't do anything about that at the beginning, you may have a problem later because it may be too late. All right. So one of the things about the what in getting your ducks in a row is what is new and you're working on and you're doing, and maybe you change it later. Okay. But let's start out knowing what you're doing. Okay. And probably you have an idea when you start the company. At least I hope you do. Okay. So in fact, one of the things I'm going to talk about is intellectual property. One of the big things to get your ducks in a row is make sure that if somebody is bringing ideas as part of their starting the startup, like, well, look at this guy. He's our CEO and he has 30 years of experience, getting LLMs to work in French. Okay. Even though LLMs haven't existed for 30 years. Good for him. He's bringing this to the party. Get that nailed down. All right. Or if you have some, clever technique that you want to maintain and not tell anybody, like, we're routing all our LLM queries through Antarctica where they have, a special cold-oriented process. Okay, you want to not tell people that. You need to have agreements in place that make sure that these, let's say, your company's secret sauce remains secret and your sauce and not somebody else's sauce. All right. Similarly, if you have stock agreements, ownership transfers, assignments of responsibility, milestones that people have to meet, these things really ought to be at some point in time, preferably or as early as possible, written down, signed off on, agreed to, over and done with, so that later it's okay. Now, there's an awful lot of people who will say, oh, well, so-and-so's my friend, he's my partner, we're working together, everything will be okay. And maybe so. I don't think there's anything wrong with working with your friend and your partner and trusting that person. And, I trust people every day. But can you trust this person's executor after they get hit by a bus? Can you trust this person's ex-wife after they have a nasty divorce? Not so good. If you start a company with founder A, and founder A gets 10% of the company, founder A has a nasty divorce, and you now are no longer in bed with founder A, you're in bed with founder A with 5% of the company, and founder A's ex-wife who is 5% of the company, who maybe doesn't like you. All right, that could be a problem. All right, so you want to have those things arranged ahead of time. And similarly, as ultimately when you go and you set up your company, you might have some operating agreement. You might have some shareholders agreements. You might have contracts for vesting of stock. You may have ownership property. You may have licenses from people that you start with. If you're coming out of like UT or another university, you might have a university license. You need to have that nailed down. You really don't want to produce a product and then have the university say, oh, by the way, we get 90% or some horrible number that you don't like. All right. So what is helpful? When? The thing I'm always going to say is as soon as possible, when you can afford it, but preferably early, not later. Well, more accurately, preferably before trouble arises, not after trouble arises. Because after trouble arises, things get really, really, really expensive. And of course, nothing will kill a startup faster than having to spend money on something that they don't have the budget for. And preferably, you want to review this kind of thing like once in a while. Every year would be fine if you're not, super changing things. If you do change what you're doing, then when you change it, you want to review it. So when I say as soon as possible, I mean sooner than trouble, okay? Before trouble arises. Okay, so naturally, there's always a where question and a who, what, when, or why questions. Okay. One of the things when you start a company, if you start a startup, you might sit down and say, okay, let's organize the business organization. There are some legal principles for organizing business organizations. And you may need, when you talk to your attorney about this, or even if you just talk to your accountant about this and say, please set this up, you may need to make a decision like, okay, where are we going to be doing business? We're going to operate out of Austin, or is everybody remoting in from, Western Bangalore? All right. If we are incorporating, are we incorporating in Texas? Are we incorporating in Delaware? Are we incorporating in Massachusetts, where all our fun people are? Are we incorporating in California, where we expect our market to be, or whatever? All right. These kinds of things should be worked on and decided. And naturally enough, and this is going to be a common theme. When you start a startup, everything is up in the air, right? You don't know what's going to shake out when you finish. Hopefully, you have a great idea for a product, you build the product, it works, you sell it. That never happens. There's always a bump in the road between A and B. And typically, the bump in the road is unexpected. Even if the bump in the road is, well, we expected this product might not work, or people might not like it, we have to change it, all right? Then there are things you might want to do ahead of time. And so, warning, things change. You want to be prepared for things changing. You don't want a messy fight later. I really did mean it about asking questions, so ask.
A question.
Yeah.
So
you don't get a quota, by the way. You can ask as many as you want.
So there was a lot of discussion in the last few months about the difference between being a Delaware company versus a Texas company, especially if you're Elon Musk. But
I'm not Elon
even
Musk,
if you're
and
not-
neither are you.
yeah. But I'm just wondering, is there by general reputation, you're not my lawyer, so but by general reputation, are there states that are especially friendly or unfriendly legally to startups?
Probably yes. I mean, friendly or unfriendly, Delaware has a reputation of being friendly to corporations.
Yes.
Okay, and part of the reason that people have been coming to Texas is because some people, notably Elon Musk, don't feel that's accurate anymore, and though they feel like they want to open a second front they want to second source the opportunity for starting corporations, and they felt Texas was an opportunity. Texas, by the way, has stepped up on that by actually creating a separate Texas court for business conflicts, so that you can, when you run to court, you get somebody who understands business, and you don't get somebody who is a religious studies major who happens to be sitting in the civil department. All right. So yes, there are states which are advantageous for startups. I mean, for example, if everybody lives in Florida, you probably don't want to go off and incorporate in North Dakota. All right. Or, if you don't want people to find out who you are, there are some states that are actually much better about keeping the founders not off the public record. Or if you want to be in stealth mode before anyone finds out about your product. Okay, if you have 3 famous people and a funder who doesn't want people to know who he is, maybe you want to incorporate under those circumstances. There are different reasons to incorporate. There are favorable tax treatments. There are favorable treatment for the board. There's favorable treatment for shareholders. There's being local and convenient for you, for operations. There are different reasons. So ultimately, you're going to talk to somebody who is an expert about that. That usually means a lawyer. Okay, it might mean somebody else. Your investors might tell you, incorporate in Florida or we won't fund you, in which case you incorporate in Florida, or else you don't get funded by them. Whatever.
So by reputation, Delaware is the place where if you ask your lawyer what would be the result if this happened in Delaware, they can tell you.
They can tell you.
And in other places, it is harder.
It's not that much harder.
Not that much harder.
The corporate law doesn't vary that much from state to state. Certain states are perceived as being friendlier, part because the law says blah, 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 and it's nice for, and there are people who have looked at that and said, yes, that's great. And partly because the courts are more responsive. You know, you go there and the courts go, oh, a corporate problem. We have people who know about that. Good, fine, right? You know, if I were starting a business here, I would say, look, okay, Texas first, you know, maybe Delaware. You know, do all my people come from California? Maybe California. Do all my people come from New Jersey? Okay, maybe New Jersey, whatever. All right. It's not a trivial decision to make, but it's usually not a terribly difficult decision to make. Okay. And by the way, it is a decision that can get changed. All right. Of course, as with all things that you want to change, changing before there's trouble is better than changing after there's trouble. So maybe you want to incorporate right where you are. And then later, when you get big enough and you say, oh, look at that. We discovered that, you know, all our people in Florida or all our people in Virginia, or we sell to the federal government and we need to be in Virginia or Maryland. Then under those circumstances, you know, it's not too hard for you to say, oh, great, we'll just change that. On the other hand, if you run into trouble and there's a big dispute, then at that point, changing things can be a real troublemaker.
I think a lot of us would agree on that.
He's a perfect example. I could tell you about what happened with that, but that's okay. Similarly, in addition to formation, there are things like, okay, so who's going to invest? What are we going to offer our investors? What is our selling proposition to these investors? Knowing these things ahead of time helps. Yes, it will change. Okay. Business changes, market changes, the people involved in the business change. You know, your chief finance guy may disappear, your chief marketing gal may disappear. All kinds of clever things like that can happen. Being prepared is a whole lot better than just, you know, getting hit with the slings and arrows of random chance, which is one of the reasons it helps to get your ducks in a row. With many of these decisions, they are what I would call a Jeff Bezos decision. Jeff Bezos very famously said there are two kinds of decisions. Kind one is decisions that are easily reversed. Okay, I want to go to McDonald's for lunch. Oops, they're closed. I'll go next door. Not a problem. Easily reversed. No difficulty. No big expense. Then there are decision type two is decisions that are not easily reversed. You know, I want to marry my girlfriend. I go ahead and I do that. That's not an easily reversed decision, and it becomes very uneasily reversed after we have children and buy a house in the suburb, and you know, yada yada yada. Okay. If with many of these decisions, it's trivial. Get them over with. Get it done with. Okay. If you need to change it later, you change it later. With some of these decisions, if you do it wrong, it's going to be a pain to reverse it. With all of these decisions, if you do it wrong and then have a dispute, it'll be very, very difficult to change, which is one of the reasons startups get messed up. Okay? Here we go. One of the big issues on keeping your ducks in a row, if you have documents that need to be done, get them signed. You have no idea how much trouble I have personally run into with people who, after everything is said and done, decide that maybe, just maybe, I don't want to sign those documents. Well, dude, we relied on you to start this company. You know, if you don't sign the documents now, we have trouble. You know, but I don't want to. Okay, well, people change. People who are very agreeable today might not be so agreeable tomorrow. People who have good reasons to be, you know, throw their hat with you might change their minds and decide they're, you know, moving to France, whatever. Okay, so having this stuff signed ahead of time makes it a lot easier.
I have a question.
Yeah, ask.
So in the last 5 years especially, I've had several cases where signing the document is they send me an email and I click a couple
And
things. It
you
says
go-
I signed it and it goes back to them.
Right.
It was never a thing that I really like, and it's an NDA that I won't talk, and I'm not gonna talk about this stuff anyway, so I didn't check it out, but I assume that that holds up, but I don't, is that been
Very,
tested?
it'll hold up. I mean, it'll hold up in the sense that, I mean, you're signing documents with DocuSign, that will hold up. There's a statute about people sending electronic copies of documents back and forth. It doesn't have to be wet ink anymore. And 20 years ago, 30 years ago, if you said, please sign these documents, that meant a physical piece of paper had to be in front of you and you had to sign it with your pen, okay? And maybe it would get faxed to the other guy or it would get scanned and emailed to the other guy, but there was an original ink copy. Now, no, not so much. There's electronic transmissions of documents. I have signed an awful lot of documents by simply writing on the bottom of the document, signed by Steve Swernofsky, and if there is a argument about it later, well, come and talk to me, right? It's very rare that somebody will sign it and then say, oh, I didn't sign that, and then there's plenty of evidence. So that's not as big an issue. But what is a big issue is someone who says they will sign the documents and then never does. Oh my God, you have no idea. And then especially what happens, and I do this, I typically file documents with the patent office, and the patent office will say, have everybody sign this document to assert that they are the inventors of this invention, okay? And A and B will sign, and C will say, I'm not so sure. And now suddenly, major trouble, okay? That gets expensive. It'll cost you several $1,000s just for me to call everybody and say, please sign this damn document, all right? And we don't want that. I mean, you certainly don't want that if you're on a thin budget, right? And thin budgets, by the way, do not mix with trouble. One of the things, yes.
Is there a difference between states? Like, some states wants to also have the paper documents signed, or this is not something?
Not these days. Not these days. I mean, yeah, if you really needed the paper document, you should keep it. But if no one can find the paper document in 3 years, or another attorney I know refers to this as TIF, 10 years from now in litigation. Okay, we can't find this document. All right, great. But there are 40 Xeroxes of this document floating around. Don't worry. Okay, now, can't find the original signed document when there are a bunch of copies floating around and no one says the copies are not proper, you're okay. 10 copies of the original, the original is still there and one of the copies is alleged to be doctored, oh, now you have a problem. But that's going to be a problem anyway. Yes.
I have a follow-up question.
Always ask follow-ups. Feel free. But this is intended to be interactive. Don't even raise your hand. Just say, wait, don't stop here.
I don't know what is the difference between a patent and intellectual property. So
Right. I'll go over that in a little bit more detail, but okay, there are many different kinds of intellectual property, and I focus on intellectual property, so I can talk about this for hours. All right. Patents deal with inventions. Okay, so for example, if I have a new way of making nylon thread, pour alcohol in one, pour alcohol over here, add some flour over here, and nylon thread comes out. That could be an invention, right? And usually to be an invention, it has to be new, it has to be useful, it has to be not very obvious, okay? But there are lots of things can be inventions. There are other kinds of intellectual property. So for example, when Disney makes a movie, the movie is copyright. It's a completely different kind of beast from an invention. All right. Now in Hollywood land, which used to be stomping grounds for me, the people will talk about properties, and when they talk about properties, what they really mean is the copyright rights to something. So for example, the movie rights to Harry Potter and the Goblet of Fire were extremely valuable. They're extremely valuable now. The movie rights to, name some other novel might be valuable, might not be valuable, depending upon whether someone wants to make a movie, whether it be be successful after they made the movie, whatever. All right. Distribution rights for a movie in another country can be separated out, sold off, or they can be licensed or whatever. Okay, those are different properties, different kinds of property. And then there are also intellectual property rights like trademarks, which refer to how I market how I brand my product and how I market it. If I sell eggs and I call them, Starburst eggs for a random name, okay, great. No one else should sell my eggs with the name Starburst eggs. Okay, great. But if I want to sell eggs under the name eggs, that's too bad. Everybody uses that name. Okay. There was a case a long time ago in which Tide, which is a product which is soap flakes, okay, there were some people who said we want to sell this product, and Tide said no, that sounds a lot like ours. And there was a big argument about whether or not Tide really could really qualify as a trademark. Well, Tide won that deal. But if they had lost that deal, just imagine how much money that would be. Because Tide, if you walk into your local supermarket and you say, I want to buy I want to buy laundry detergent, and you'll find like 25 different kinds of laundry detergent, and theirs is very, very, very popular. That makes a big difference to it. Coca-Cola, for example, is known to be one of the most litigious companies in America because they feel, and rightfully so, that the name Coca-Cola is extremely valuable. Okay, I'll get to that in more detail a little later, but I don't want to mess it up. Also with signed documents, and this is something that I often warn people about, please get a professional to look at your documents, at a minimum. I mean, it's very easy for people, to come up with some, first cut documents and go, looks good enough to me. And maybe it is, but if you start with something and you go, great, this first draft is good enough, who knows, maybe 9 times out of 10, it's not a problem. But that 1 time out of 10, when it is a problem, boy, is that terrible, right? So one of the ways startups mess up, okay, is they don't get somebody to look at it. Now, this is something I have said over and over again. And if I say it twice, it's because it's a common problem. That feels expensive, but it's probably the cheapest money you'll ever spend. Okay. All right. Employee agreements. This is an example of documents you care about. Get these signed. All right. Even if it's, this guy's obviously an employee. All right. Or even if, typically employment agreements will have a couple of things that really, really matter. One of them is assignments of what the employee does for the company. All right. One of them is non-disclosure agreements. This is your NDA that you went and click through. All right. I assure you that is a standard document. All right. I've seen some of them where the company tries to be a little bit pushy about it, but 99 times out of 100, it's a standard document. I've read them. I've read hundreds of them, and they all look the same. Yes, I agree that the company will tell me stuff that is important to the company, and I should not blab about it to New York Times. Good. Sign them. All right. 9 times out of 10, 99 times out of 100, not an issue. Vesting schedules. If people get stock, if you care about that, and they will care about that, what that schedule is, that will matter.
I have a question for you.
Yeah.
More of an employee side is like, I read all these things, and sometimes it's just like they're a little.
Oh, they're awful.
They're a little awful, right?
They feel like you're putting yourself, putting your wrists in a chain when you sign those documents.
Oh, where it's like, your time outside of work, you're spending doing projects is like kind of technically still owned by them, or like.
There's a certain amount of overreaching that sometimes occurs. Most states will say that if you do stuff on your own home, with your own money and your own equipment, and you don't use anything you found out from the company, then it's yours. Everything else is theirs.
Yeah. Okay.
So if you use the company's equipment, which by the way includes your laptop if you got it from them, or you use the company's time, like you did it while they were paying you, or you use the information that the company told you that you couldn't find out anywhere else, like, oh, look at this, the company does blah, 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 and I'm going to use that to build a product. or, it directly competes with the company or something like that, yeah, that could be theirs. And sometimes companies get a little aggressive and you can look at that and go, no, dudes, that's not right. You'll have a little bit more gravitas if you say, my lawyer says, no, dudes. Okay, but often you can just go back and say, no, this is pushing it. And
Well, so like when I said, ask other people with like more experience than me, they're like, yeah, that's kind of usually the standard dot. Like some of them are kind of standard language.
Usually.
They're like, yeah, but if that ever did happen, like you can kind of argue it. So like, I don't know. Would you just kind of sign it, or would you want to go back to them and be like, oh, I don't really like this idea that like every idea I ever speak to you is like now yours forever or something like that.
if you don't like it, the smaller the company, the more likely you have some bargaining position. All right. If it's a huge, if you're working for Walmart and they say sign here, and you say no, I don't want to sign here, they'll say great, just leave.
Yeah.
Okay. On the other hand, if you're working for a new startup, and you're creating, Unicorn Seashells Inc. and you decided to sell seashells, and that's great. And you'll say, no, I don't want to sign this here thing that says everything I ever thought of is yours. And they'll go, well, what do you think it should be? Or they'll go, no, that's the standard agreement. And you'll go, well, it shouldn't cover blah, blah, blah that I'm working on in my spare time.
My question is, do you think it would just go back to their lawyer and then be like, oh, it's standard language, just like not a big deal?
If it is standard language, but
I don't know exactly. I've only looked at.
I've seen people get carve outs. They'll say, oh, I'm working for Unicorn Seashells, and I'm also working on this project in my garage for this other company that sells spaghetti monsters. Okay, and you go, great. And they'll go, great. We'll exclude that. Please write that. I'll write a paragraph about what it is, and we'll include that.
Yeah.
All right. If they're real jerks, they'll say no.
Yeah.
But then again, if it's a small company, they can't afford any real jerks just yet. Yeah. How about this guy? Then you feel free. You can ask as many questions as you want, but everyone gets a chance.
What type of employee agreement, like I'm aware of in Texas versus California, is like the non-compete?
Yes.
That was my question anyway.
That's a valid question, and different states have different rules about enforcing them. California does not like non-competes, and anybody who works in the software world has found out about this. Texas is willing to enforce them. And on the other hand, non-competes are more likely to be viewed by the courts to be overreaching. So if you have a question about a non-compete, by all means, first of all, what are they asking you not to do? And second of all, maybe you need to talk to a lawyer.
How should we think about, so, let's say a person's about to co-found a startup with some early employees or maybe some co-founders that come from other companies, maybe they're in Texas, they probably signed some sort of non-compete.
Possibly.
And so now, make sure like the foundations of your company are not going to have this like prickly problem. Like, what is the process of ensuring non-competes are not going to be an issue from the prior employer? Like, are there guarantees you can get?
I'm kind of doubting that there will be guarantees, but I mean, one way you could get a guarantee is you could go to the former employer and say, I'm going to do X, tell me it's okay. And they say, yeah, that's fine. And you go,
Get it in writing.
goodbye. Get it in writing. Yes. I mean, this is one of the reasons you need documents, because people change their minds. Even, if you work for a company, if you work for a major corporation, like, major whale computer manufacturer, and major whale computer manufacturer, your manager says, it's fine, don't worry about it. Okay. And then later he leaves, gets replaced by someone else, and someone else says, I don't remember saying that. Having it in writing will be a godsend, because it will make a real difference. You go, I got it in writing. They'll go, oh, okay. On the other hand, people might be reluctant to give it to you in writing because they don't know what they're giving away.
How should startups think about like having their own non-competes? I mean, if you hire like some early employees, you have a lot of secret sauce. You feel good, that goes beyond the NDA.
It does.
Is that something that a startup in Texas should do because everyone else is using that legal document to protect their IP and other various things? Or
I think it depends. The first thing you need to look at in all of these cases is it's not just the legal issues, it's the business issues. So let's look at the business issues first, and then let's see how the legal issues can be moved to serve the business issues, right? If you're a startup and you are the first people to think about using machine learning to sell seashells on the beach, okay, then by all means, you will want your head people, your chief of technical operations and your operations officer and things like that, to swear that they're not going to go off and quit and do this the next, in 6 months from now. Okay. On the other hand, there's a certain amount of overreaching you really want to not do. All right, because your whole non-disclosure can go, non-compete can disappear if it's overreaching. So if you say, look, we're going to sell music to Hollywood, all right, and you say to people, your AI music creation device that also sells Cheetos in its spare time can't be marketed in anywhere in the U.S. Fine. Anywhere in the world, including Nairobi, probably not fine. All right. Or this particular person, can use his general knowledge about whatever his technical background is if he ever leaves, but not on this particular topic. Probably fine. On anything, definitely not fine. There's a difference. As a startup, I would be careful about things like that, and I would be very, very careful about overreaching because that can be a pain point, and you don't want that kind of pain. You'd rather it was very clear. So and so agrees to do ADC for you, won't do ADC for anyone else for 2 years. Stop.
Is the term defined?
It does matter.
The overreach 6 months versus 10 years or something.
Yes.
That is
Makes a big difference.
Yeah.
Yeah. 6 months versus 10 years, 2 years versus forever. It can make a real difference. Yeah. And you were first, but let's get everyone.
The audience was, what's like the difference between once you get a signature or a notarized signature?
The major difference is that with a notarized signature, that the person wasn't under duress. It's really them. The main reasons you would do that is, or maybe there's some requirement that the company feels it needs to satisfy. In most cases, just a signature, but in some cases, a notarized signature will be wise. All right. In the case if you're the person who's signing and they want a notarized signature, usually my gut reaction is just do it. If you're, tell them they have to pay for the notary. All right. If you're asking for a notarized signature, mostly you don't, but this is again, get a professional. Yes.
I wanted to ask about the agreements. Are these one for the employees or also for interns and for bidding?
I would get everyone to sign.
Yes, everyone.
Even if it's just tie your hand around the place and we're teaching you how to behave, sign. I mean, the document can say, we're not paying you. We're not paying you. You're getting credit at your local community college. You hang out 10 hours a week. You behave yourself while you're here. Great. Sign here. How hard is it? Yes. You had a question. I know. If you were first and you were next. But it was the same question. That's fine.
Also,
Yes. Sir.
so say I'm in a startup,
Right.
self-funded, friends
Right.
and family.
Right.
What's paid from a legal standpoint, financially, to come up with all these documents?
You mean how much will it cost?
Yeah.
If it's not a complicated thing, it probably costs you under a couple $1,000s. I mean, I'm just guessing. How complicated is your startup? How many people are involved? How hard is it to chase them down and ask them to sign things? It shouldn't be that difficult. It sounds horribly expensive when you're just starting out and you're pinching pennies. But everything that costs you $100 today will cost you $1,000 if there's a complaint and $10,000 if you have to go to court. So in part, it's like, well, do I want to take the risk? And for some circumstances, you say, fine, we're just getting started. If it blows up, it blows up. And in some cases, you say, well, we have 6 employees, and we have to, and we're looking at renting an office, and that's going to cost us $4,000 a month. Maybe we should get this signed off and checked out. At that point, yes. This is a business decision. Again, legal considerations should serve your business considerations. And business considerations are, what I'm mostly talking about is, you don't want your company to blow up because you made a mistake early. But, certainly you don't want to overdo it on, dotting the i's and crossing the t's, because then the company will not blow up early, it'll just never launch. You don't want that. I mean, good lawyers will tell you that. They will say, we don't want your company to starve for lack of funds. Good to know. Let's be good about it.
One thing you should also let know, because some companies also require copyright assignments or copyright for assignments.
Yes.
And what happens with longer companies require this, and they can excluding these ones.
Right. And they will typically say, excluding everything in Schedule A, please fill it out.
Yeah.
If you have anything, you should fill it out. And at that point, if you're going to do that, if you're the employee, you should certainly fill out Schedule A and be as complete as you can. Even if it's just, item 5. I had this bright idea about blah, 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 and I haven't worked on it yet, but if I ever think of anything, it's not yours. Good to know. Because the company will look at that and say, fine, check mark, then they check a box.
I have like I feel like much help and they just sign it without questions.
Of course they do. Because they're not going to get into an argument about, with you about your new method for making bubble gum if they sell computer software. They don't care. Yeah, I mean, certainly if they sell computer software and you have a new method for some other computer software, the very first thing they're going to do is they're going to say, do you care about this? And if the answer is no, then they'll have a check mark. And if the answer is yes, then they'll talk to you. Yeah. Anyway. Okay, let's make this interactive. Okay. Okay, so what is this slide about? Money. Okay, well, that's money also. Okay, so you really want, especially when real money starts getting involved, you want to have things arranged in a relatively clean manner at front. The first and biggest, my bad. Stop. The first and biggest mistake is people raising money and not having a clear deal or a clear arrangement as to who's putting in money and how much and what they're getting out of it, what the company is promising them, and things like that. Especially with investors, professional investors who are really hard-nosed about this. Friends and family will typically say, "Oh, you need this much? Yeah, fine." Or, they'll write you a check, and there won't be a good memorialization of what that was for. Please write it down. It helps. Professional investors, also known as the devil in this slide, will offer you deals that stink. Or they'll offer you deals that look good but stink. Or they will offer you deals that are good but they have a catch. At a minimum, have someone look at those who knows something about the deal, even if it's not your lawyer. Maybe your accountant has a good idea. Or maybe, maybe your friend, Billy Bob, who started a startup and dealt with VCs or angel investors a while ago, has an idea. But, don't just sign blindly. All right. I know at least one company that I read about where the founders had this absolutely fantastic company. They started it up, they got venture investment, and they had a successful exit 5 years later, and they sold the company for $30 billion, and the 3 founders managed to split $5 million. All right, which sounds like a lot of money, but after 5 years, it's not. All right, and the reason was that the venture investors had offered them a deal which effectively kept most of the upside for themselves. So careful. And then finally, there's the inevitable deaths and taxes, to which I always add, and laundry and traffic. Okay, now I can't do anything about death. Okay, I can't do very much about traffic or laundry, but I can deal with taxes. Talk to your accountant. There are several things that are important, especially for startups, on how you hand out ownership shares, whether people have qualified for their shares to be what we call QSBS, qualified small business shares. This will matter, especially with the small business shares, because the taxation on that will make a big difference if you have done it right versus if you have done it wrong. At a minimum, talk to your accountant. Your accountant should know what's going on. If your accountant doesn't know what's going on, you may need to talk to a corporate lawyer or a tax lawyer. You want this to be right, because 10 years from now, when you're talking to the IRS and you have, look at this, wonderful exit that you just made. You sold your company for $30 million, and the IRS is going to put its hand out and say, some of that is ours. And you really would like to say, not much. Sure, some, but not all of it.
Question about that. So,
Yeah.
If one is bootstrapping their startups, they're using their own personal savings income, and so that means like they might benefit from assuming the startup's not making money right away. They have
Mhm.
lots of losses, so incorporating as an S corp or some other pass-through entity, so they can have some of those business losses they count from their personal income to offset tax
Right.
liability. And then let's say like earlier rather than later, there are some venture capitalists that get interested. All of a sudden, they want to invest $500,000, but it's predicated on, of course, you have to be a Delaware C corp. How fast could let's say you raise the money, they want it to be a C corp. Would one completely screw themselves by starting as an S corp, or is it
No.
possible to?
No, you can reincorporate. The answer to how fast is going to be almost certainly not as fast as you'd like it to be, and almost certainly faster than you might be afraid of. But yes, you can reincorporate. If you incorporate in Texas as an LLC, and then you look at it and you go, that's not really a bright idea. We have better tax consequences if we incorporate in Delaware as a C corporation or a B corporation. That's doable. It will cost you, right? And part of the not screwing up formula is do stuff that won't cost you later. But if it does cost you later, sometimes the answer is it's perfectly justified. We're going to get $500 million in investment. Just spend the money. The VCs will, by the way, make you pay for that, even though you're getting their money. They're happy with the new corporate form. Just deal with it. Okay. This is one of those decisions which it's reversible. It might not be as trivial or as easy to reverse as where you decided to go to lunch, but it is a changeable thing. You definitely want to talk ahead of time to people as to how much can I change this decision if it turns out to not align with the future. But yeah, it's usually doable. I make no guarantees.
And like, let's say you already have founders, and you might have signed some employee agreements, S corp, and then reincorporate C corp for Delaware. Those things can transfer over, or you have to redo everything.
There will be ways to transfer them over, or if necessary, you will have to redo them, and the person will have an obligation of some kind to do so. There are ways to deal with that problem. It will rarely be the case that you have your chief technical officer signs an agreement that says he's going to get, this much and this many shares and do this and these milestones, and you reincorporate it in Delaware instead of Texas, and suddenly he's free and clear and doesn't have to do anything. I doubt that. Or suddenly you're free and clear and don't have to do anything. That's also doubtful. Again, it's going to depend very much on what the specific facts are. Like, you were going to originally sell seashells and suddenly you're going to make bubble gum. They might be completely different. You might look at that and say, that's not me. Leave me out. Right? Different world. Okay, IP protection. I do a lot of IP. I'm an intellectual property lawyer. And so I talked a little bit about what patents are. Patents relate to inventions. There are different kinds of intellectual property. Patents are one of them. Trademarks and what we call trade dress, which is not necessarily the word or logo that you use, but the shape of the product will also be protectable. Usually, when you have an early stage startup, you will not care about this because you won't have a product. When you do have a product, then you will care a lot about this. Copyrights, which again, we talked about movies as an example. As it turns out, copyrights also protect computer code. So that will be relevant if you're a person who codes. If you generate code, yes.
Is there a reason one of my principals makes us write Black Locust copyrighted 2025 on top of every file? Does that mean anything like that in private repo?
The answer is no, not anymore.
Not
Yes, there used to be a reason. There used to be a reason, and under the old copyright law, which has now no longer has much effect, if you did not have a copyright notice on your product, a copyright notice on your copyrightable work, then it was not copyrighted. Now, the copyright notice mostly serves to warn people that, yes, someone claims a copyrighted this, and if you copy it, you're making a big mistake. All right? Now, in the case of code that is on a private repo, that no one is going to walk off of that code without actively taking it off their private repo, which they will hopefully know they should not be doing, and they will have a very hard claim that they are innocent of wrongdoing in that circumstance. But yeah, if he makes you write Black Lotus copyright on
I
it,
just
so
call them old.
yeah.
I just call them old.
You come, what?
Call them old. Okay.
Oh, what?
Call them old. Old.
Oh, yes, yes.
Oh, yeah, yeah. Just do it.
Not very 20th century of you, but I'll do it anyway.
Yeah, exactly. I had an employee a long time ago who was typing out bills on an electric typewriter, and I called her over and I said, "That is 20th century technology. We don't do that here. We use computer code. We use computers and we send out spreadsheets." We wouldn't do it. Oh well. Yes.
The software is quite difficult to protect in courts and depending on the jurisdiction, right?
No and yes. No. Software is definitely copyrightable. And someone who walks off with your software or makes, or changes the variable names, it won't do them a bit of good. On the other hand, other kinds of protection, like patent protection, software might be difficult depending upon what the invention is, right? If you have an invention which is mostly implemented in software, it might be the case that invention is protectable and you won't have a worry about it. You will go to the patent office and they will say, fine, hunky-dory, everything's good. And sometimes you will go to the patent office and say, I have this great idea. And they will go, yes, but that's not patentable. And you will go, why not? And they will give you some mumbly answer, which you will not understand and you're a little bit frustrated about and tear his hair out. And that's why I don't have my show. But yes, software is generally, in general, depending on the facts, in general, protectable. Don't worry about that. If you are working for a company and they are paying you to write software, it will be theirs. Be careful. If you have an invention, they will have asked you to sign an invention agreement, and you will be obligated to assign it to them when you're done. Yes, software is usually protectable. Yeah, go ahead and follow up. Yes, I saw you. Don't forget. I won't forget.
Is there when you need an IP? Is there going to be an installation of the jurisdiction until you get somewhere like?
Usually with intellectual property, you're in federal court. You won't, with intellectual property, you will be in federal court if you have to go to court. If you are applying for a patent or a trademark, you will be going to a federal agency. If you are,
If you have international problem,
if you have an international problem, you will need to have arranged this ahead of time, but no, there's not an escalation. What will happen is that with the international issue, you will typically end up in the courts of the country where the problem is occurring. And yes, yeah, I can see you grimacing. And yes, that's a problem if the country happens to be a country that, say, isn't very friendly to you, doesn't speak English, or is having a trade dispute, or some other terrible reason. Yes.
if you bought it in Britain, does it help?
If you're selling or making the product in Britain, the traditional patents protect making, using, or selling the product. If you're making the product or selling the product in Britain, a British patent will be helpful. It may not be as helpful as you might like because the Brits treat patents differently from the way the American courts do. As it turns out, conveniently, Britain is part of the European Patent Organization. Despite not being part of the European Union anymore, the European Patent Organization can still grant and does grant patents that are valid in Britain. So if you want to have a patent in Britain, you are actually able to go to an agency that will grant one that's good for Britain, France, Germany, Italy, Sweden, like that. Yeah, go ahead.
But do you have a problem in Asia, anywhere
You will
outside
need a
of?
patent in that country in Asia. So if you want to enforce your patent in Japan, you will need a patent in Japan. And you will need to get the Japanese patent office and the Japanese government to agree. You want a patent in China, you will need a patent that is agreed to by the Chinese government and their agency that deals with that. If you want a patent in India, you will need one in India. If you want a patent in, if you want a patent in Singapore, you'll need the Singapore government to agree. Okay. As it turns out, one of the things I often do for people is I tell them, this country is worth the cost. This other country is not worth the cost. If you have a bright new invention that has to do with, artificial intelligence and software code that runs on the hottest new processors that you can buy from the hot new processor people, and you are thinking about getting a patent in, let's pick a country that's really unlikely. It's
North Korea.
North Korea. Don't do that.
India or China.
India or China will make a difference. China, yes. India, probably not. Okay. Certainly Kenya, no. No slur on Kenya. It's a wonderful country, but it's not a big economy. And even if you have a patent that is good throughout the European Patent Office, you might look at that and say, all things considered, I don't care too much about the market in Austria. All things considered, I don't care too much about the market in Hungary. Maybe that's true. Maybe it's not true. Depends on your product. I actually worked on some patent protection for a company who made a product that could be literally made in your bathtub, and it was good for roughly 5 to 10% of the human race. And so they were willing to spend literally millions of dollars on patenting this particular product, and I had to write letters to 175 different countries, and it was painful, but it was worth it for business reasons, not for legal reasons. For business reasons, they care if you were willing, if you were going to make this product in Italy or in India or in Pakistan or wherever. They care because it made a difference. But most products, no. I mean, if you have a new idea for how to make automobile engines better, there's like 8 countries in the world where that matters, at most. Yes.
So I worked for a company once where the lawsuit saying we've infringed some patents happened, and the CEO who had done this at several different companies said, basically, this is a rite of passage, and every startup that is successful is eventually going to get sued, and this is now our turn. And I'm just curious as to your opinion of that statement of it's a rite of passage. It happens to any successful company eventually.
Generally, yes. How successful you have to be before that happens depends on the industry. I did work for one company where they broke $1 billion a quarter, and they got a whole bunch of letters like right after that. Hello, we're IBM. You infringe our patents. Which ones? Well, we have 30,000 of them, so probably at least one. Yeah, they got sued. Yeah. Well, Disney sued Midjourney recently because Disney claims that Midjourney's products infringe Disney's copyrights. And, one of the things, it's a valid point. And one of the interesting things about this, I'll get to you, don't worry. One of the interesting things about this lawsuit is that Disney does not claim that Midjourney is actually copying anything Disney wrote in the way of, generated in the way of movies or wrote in the way of scripts. What Disney claims is that the characters from the movie are being copied. So, for example, Midjourney. If you ask Midjourney, please give me a photo of Darth Vader on a unicorn riding a spaceship, it will happily do that, and Disney will be upset. Yes.
So in this case, how likely are you to avoid court, or how profitable is it to avoid court?
It's generally profitable to avoid court.
Is it likely to?
In this case, in the Midjourney case?
A software.
The rite of passage.
As it turns out,
software, IBM.
almost always that rite of passage is, hi, we're so-and-so major company. We have N,000 patents. You infringe at least these 10, pay up. And the rest of the discussion will be how much. Okay, it will not be a question of do we infringe or don't we infringe. That will be, you could argue about that, but ultimately, people will chat about that and they'll have discussions and there will be arguments about it. But at the end of the day, that either goes to court or it doesn't go to court, right? Well, if I thought you were infringing my patent, whether that goes to court or not is going to depend on how much you're willing to pay me for it, right? Pay me to not go to court. If I do go to court, then there will be a decision from the court. Maybe it'll be yes, maybe it'll be no. If I'm suing you and the decision is yes, you infringe, you're unhappy. If I'm suing you and the decision is no, you don't infringe, I'm unhappy. Yes.
I have a question about the copywriting licensing. Is this the similar path regarding registering in any country like the patent or the licensing for trying to pass different?
Copyright has different rules. In the United States, if someone has published the work pretty much anywhere, and then it gets copied by the alleged infringer, and the copying is done in the United States, or the publication is done in the United States, you will not have to go on and register it. Patents are harder to get and stronger if you do get them. Copyright is easier to get and less strong because the standard for what infringes in the world of copyright is different from the standard for what infringes in the world of patents.
Do you have to register for that, or it is
Typically, no. The rule here is that if you want to go to court, you must register before going to court. But registration is pretty much a matter of you fill in the form, you pay your $40, you send them the documents, and they go, great, you're done.
That's the thing you were talking about that changed a couple decades back, right?
Yeah, no, actually. It used to be that you would have to publish the work with a copyright notice and register it. Now, all you have to do is say, I thought of this, here it is. And they go, yeah, that's fine. Did you fill out the correct form? Yes, you did, you're done. The Library of Congress that handles that, the Copyright Office, which is the name of the Library of Congress, charges you $30 or $40, and maybe it's long. Maybe it's more now. I haven't filled out that form in forever. And they will send you back a yes, you're registered in something like 5 or 6 months. For sure. If you literally have to go to court tomorrow for some reason, you can get an emergency handling, but that's more expensive. But it gets done. They don't examine it, unlike the world of patents, where you say, I invented this, and the patent office will say, well, let me think. Maybe that is a clever invention, and maybe it is not. In the world of copyright, they just go, yeah, that's fine, and say so. I'm sorry, I missed you.
Yeah, that's right. So I'm having a really hard time seeing these reasons for patents suggested big companies are using them to just troll each other. Essentially.
When you say big companies are trolling each other, what do you mean?
So what I mean is that if you have IBM, Apple, Microsoft, Google, and they have a mutual agreement not to sue each other with patents, and if you have you're a new player, now you cannot enter because you're getting sued by all.
It could happen, yeah. If you're a new player, depending upon what you're doing, they will either come after you or they won't. The reality is that most of these companies are not going to try and put you out of business because it's more profitable for them if you just pay them a fee.
Right. But this
Usually.
this fee, it doesn't bring any value.
Is the APP on the big boys?
You know,
Big boys club.
in some sense, you can think of it as an entry fee into the Big Boys Club. If you are entering the Big Boys Club, you can afford that fee. If you can't afford that fee, you're not in the Big Boys Club. Look, there's a certain amount of philosophy question here. There's a certain amount of public policy question here. And the public policy question is, the whole purpose of intellectual property to begin with is to reward people who come up with new ideas, new thoughts, new expression. And because we want to reward people, the way we currently reward them is that they have the right to exploit that product. And if they make somebody else pay for it, that's how they get rewarded. Now, yes, 400 years ago, the way people got rewarded for new ideas was they went to the king who said, that's a great idea. Here's some land title, or, here's 40 pounds of gold, or whatever they used to give you back then. Now we make the market enforce that. And yes, it's a payment of a fee to get into that club, but then again, you didn't think of most of the ideas that club is using. So yes, that's good. Patents expire after a while. As it turns out, unfortunately, in the computer world, they last what is effectively forever because they last 17 years, which is, well, 20 years from the date you apply or 17 from the date they issue. Yeah, there's always a lobby to extend it. And the reality is, in the computer world, that's forever in terms of technology moving. But it used to be the case that that was not forever. I mean, if you come up with an invention today on new control devices for driving the car, it might be easily that long before it really gets marketed and developed. So
In biotech, it's still
in biotech,
a big issue.
It's a big
because
issue.
It takes them so many years to get it through approval. Yeah.
actually, there are special rules for biotech about
Because of that
we get
issue.
to have there's a possibility of getting an extension for biotech inventions that have to get approved by the FDA. But generally, the way that people get rewarded for coming up with new ideas is that we let the market enforce it by giving them the exclusive rights to the new idea. It doesn't have to be that way. That's the current political policy. If you think it should be changed, get on a soapbox. I would be the very first person to join your soapbox if it's a good idea. That is, if I think it's a good idea.
And another question is.
I did see you, so you're next. It's fine.
Yeah, another question. If big companies just can essentially ignore copyright law because they are, as far as I know, committing millions upon millions of copyright infringements to actually do the machine learning.
That is a different question entirely. First of all, is machine learning a copyright infringement?
Making copies of documents is.
Yes, making copies of documents when you haven't paid for the copy is an infringement.
Yes.
But feeding the document into your, let's pretend you do pay for the copy, so it's a valid copy, feeding the copy into machine learning device to compute a bunch of weights, which are later used for statistical output of a different document, might or might not be an infringement. Now, I have seen 3 court cases on that particular question, and so far, 2 of them have said, no, that's not an infringement. Okay, so if you believe that is an infringement, that's the kind of thing that we can go to the courts and try to convince them, or we can go to Congress and try to convince Congress to change the rules. But, is that an infringement or is it not an infringement? Currently, that question is up in the air.
I was specifically asking about making copies because.
If you literally make a copy, I mean, in fact, I think Anthropic got nailed on this very recently. There was a case I'm sorry?
They pay the fine. They agree to pay the fine.
They agreed to pay, it's not a fine, and they agreed to pay a license fee.
Yes.
I think this case was in Pennsylvania. So what happened was a collection of authors sued them and said, you're copying our books. And it came out that what happened was Anthropic had bought a bunch of books and scanned them and threw the books away. Okay. Found another bunch of books that they just downloaded off the internet. Okay. And then they took both of those collections of books and fed them into a machine learning algorithm to generate weights for a large language model. So there were 3 questions about, do you infringe? Do you infringe if you download the books off the internet? Answer, yes. Do you infringe if you buy the book and then scan it and throw the book away? Answer, no. Do you infringe if you run the book into a machine learning algorithm and generate LLM weights? That court said no. Okay. And Anthropic said, well, bummer. At least one of the things we did, we have to pay for. So they came to an agreement with the plaintiffs. And they said, we'll pay you if you got this lawsuit. And plaintiffs said, not a problem. That's what we wanted. Now, admittedly, there are other facts that could come out. But as a general rule, so far, if you make a copy, and you shouldn't have made a copy, like you downloaded it off the internet, and you copied the book, copied a video off somebody's, off somebody's DVD, or heaven forbid, videotape, then yeah, that's wrong. That violates the Copyright Act. And yes, you're paying for that one if you get caught. Yeah, I'm sorry, it's not the best answer in the world. If you feel strongly otherwise.
I understand, but I think, yeah, I see the legal situation. It's just it's singularly weird.
Look, reasonable people could differ on whether or not that should or should not be considered a copyright infringement. And because reasonable people could differ, that question is going to be up in the air until the courts come up with some final answer and say, yes, you're stuck if you do this, or no, you're not stuck if you do this. No, it's fine. I mean, and this is a perfectly reasonable thing. If you are starting a startup, get back to our original topic, and you are relying on being able to do this, then be warned, this could be a major bump in the road. If you are, if you're relying on being able to do this and you can't defend yourself, it will be a major bump in the road.
I like your phrasing, which is it's a major bump in the road, but it's not lethal.
No, not necessarily. So yes, that's right. Now, what is lethal is if, some government decides that, no, you can't do that at all. That will be a serious problem for your startup because they'll be stuck with some rule that says, don't do X or you go to prison, and then don't do that. And yes,
Yeah, outside of LLMs, I
Yeah.
heard before from intellectual property lawyers, that is more defensive to patent business processes than software, because then you have a more likely to protect your company.
it's very difficult to patent a process that is purely a business process, but there are plenty of business processes that are physical processes that have a business use. The example I gave of making nylon, for example, that's a real world invention. As it turns out, there are chemical ways of making nylon, which is a polypeptide, and turns out to produce strands of material, which we now know is nylon, which can then get made into clothing. Well, as it turns out, when nylon gets manufactured these days, it's manufactured in a factory that is roughly the size of this city block, and the amount that gets made is literally a train car load of nylon at the same time, and then it gets shipped off to somebody who can weave it into a product. The invention of making it to begin with is patentable. Now, if you mean business processes like, people come in and they apply for an internship and you make them fill out this form, and then we evaluate the form according to these 5 characteristics, and we hire the ones who, have a score of at least 17, and don't hire the people who don't. That might not be patentable, depending upon the facts, right? That will be tough to defend. Okay. Just now, when we're talking about software, I have software which converts sound files into pretty pictures. Might be very defensive. I have software that reads a sound file and tells me whose voice that is, and that might be very patentable. I have a software that takes an analog sound recording and turns it into a digital sound recording, and it's probably not patentable. Just probably. I can't say for sure, but likely not. Okay, and it's going to depend very much on what the technology is, what facts are surrounding the technology.
There's one question from the audience is why is
Anyone?
it
Yeah.
and
Go ahead.
LLMs patents copyrights apparently treated as a special case. They consume public data, books, ideas, feed this data into the LLMs, but then they can keep the data used privately.
Well,
The weights thing that you're talking about.
yeah, when it comes to language models and what is typically referred to as AI these days, and language models, when you take the documents that you're looking for that you start with and translate them into weights for a language model, you're not literally copying the document, you're copying statistical information about the document, and you're generating these weights for the language model, which aren't a copy of the document. They are information which will lead to similar documents in the future. Okay. Does everybody get me on what the technological difference is? Now, in the world of copyright, to infringe someone's copyright, you need to make something that is either A, a copy, or B, something that we call substantially similar, so it looks like a copy. Okay, and ultimately the second one is, does some human being think that it's close enough to be a copy? Yeah, I know. It always gets frowned from the audience when I say some human being thinks it's a copy because, that's a fuzzy question, right? Now, the world of copyright has an actual get out of jail card. Okay, not necessarily get out of jail free, but it's at least get out of jail.
Residential part.
No. And this is called, in the world of copyright, this is called fair use, right? And the best way to analogize this is, suppose you write a book and I want to quote you from the book. And I want to say, look, here's 2 paragraphs that George wrote in his book. All right. Now, in the world of copyright, that is said to be a fair, quote unquote, use. It's a use of what you wrote. I admit that I'm copying these 2 paragraphs. And it's fair. Why? Because I'm commenting on your book, or I'm educating my audience about how they should go buy this book or how they should not buy this book. Or I'm examining this book and its context with other books, or saying it's well written or badly written or whatever. But there is a doctrine that was originated very, very long ago and actually is in the copyright code. Here, you can look it up. It's section 107. And it says, under certain circumstances, uses are considered fair and they're non-infringements, and under other circumstances, they're not. Now, what people who produce language model weights have been saying is, this is fair for us to do. And the courts have a number of things that they look at. And what the publishers, the original authors have been saying is, no, it's not. Okay. And so now, some decision maker has to look at that and say, well, do we think that's fair or not for you to be able to do that? And so far, most of the decision makers have come on the answer of, yes, that's a fair thing to do. Now, I admit they wouldn't be able to do that at all if they hadn't gone and looked at the book. And mostly the victory the authors have won is that you have to actually get the real book. You can't just download copies from the Internet Archive. On the other hand, the victory that the language model makers have won is that the courts have so far mostly said, not entirely, that if you do this using legit copies and you create weights for a language model, which can then spit out text, which is not a copy of the document, but might be written in the same style, that's okay. All right. So currently it's kind of a split decision. And if you're allowed to have the information, you can use it for whatever you want, so you can use it for something else later. Right. I hope that answers the question. And the person if our remote audience has a follow-up, I'd love to handle it. Do they have anything? Not yet? Maybe later.
I have
First, then you.
So, big company comes to me and says that I'm using their IP. And I go, how much? It's a license to use that IP.
Right.
It's probably not going to be perpetual, so I have to negotiate like one term.
Yeah, that's probably right. And the negotiation is just whatever you guys agree from a business perspective. Sometimes it'll be, great, we'll give you a 5-year license, pay this much. Sometimes it will be, great, we'll give you a 2-year license, pay this much, or pay this fraction of what you sell. Here's, each, you add 2% to the cost of everything you sell, and you should shuttle it back to us. Or, no, we won't give you a license at all, or we'll give you a license, but it's only good in Texas, or something like that. And in fact, any of those is okay. That is a business decision. The way that your startup avoids trouble is by not ignoring those letters, right? There was a while ago now, I think it's like 20 years ago, there was a company, BlackBerry, they used to make cell phones, and BlackBerry got a letter from some people who said, you infringed our patent. And BlackBerry said, these guys, I can't be serious, and threw the letter away. Well, later, the company who said that sued them and went to court. And the court said, well, dudes, you knew this patent existed. Why didn't you do something about it? And they were sitting there going, oh, we threw the letter away. Oops, shouldn't have done that. It would have been a lot better for them if they had gone, okay, we'll pay for a license. No, you want this much, that's too much, we'll do this much. If you want to sue us, you can sue us, or you can take this much now. It's a business negotiation. All right. As it turns out, this court, or this case went to court, and the company, BlackBerry, eventually said, well, we desperately need a license because this court decision won't come against us, in which case we can't sell BlackBerries anymore. And so they decided to pay the people who had the patent company leading this research in motion $600 million. And that was back when $600 million was a lot of money. That's a family joke. No matter how big the amount is, that's always the joke. Oh, well, that was back when $3 billion was a lot of money. It's still a lot of money. Okay. And it really hurt them. You know, one of the reasons that you don't see BlackBerries in every game these days is because they hit a bump, and it was a big bump. Yes, I didn't forget you.
My impression, and I'm just wondering if it's your impression also, is on the LLMs and IP thing, the Supreme Court will eventually give us a standard, but they don't want to until they've seen enough lower court cases happen. And so they're going to not accept the case on it for several years. And so we can assume that this will be somewhat uncertain for at least
A while.
several years, because the Supreme Court doesn't want to dive into LLMs until they've seen other lower courts do it. Is that
Probably, yeah. I mean, it may never get to the Supreme Court. It might be to all the appeals courts. The United States divides its court system up. There are trial courts. Okay, so for example, there are 4 trial courts in Texas: Northern District, Southern District, Eastern District, Western. And then there are appeals courts. The trial courts in Texas answer to there are 14 circuit courts, which are appeals courts. Texas, 4 Texas districts, the 4 Texas trial courts answer to the appeals, the 5th Circuit Court of Appeal, which sits in New Orleans. All right. And then from the appeals courts, if you don't like that, you can ask the Supreme Court if they will take the case. And the Supreme Court will sometimes take it and sometimes not take it. As a general rule, the Supreme Court's rules are they will take the case. It's a positive sign if 2 appeals courts disagree.
yeah, because then you don't, then the law is sort of
And then it's uncertain
different in different.
and they feel like they should resolve that.
Right.
It's a positive sign if it's an issue that is of major importance and really needs to get handled right away. So, for example, last week, the Supreme Court heard the VOS case, which was on whether or not the president has the authority to impose tariffs on foreign sales. Okay, well, does he have the authority or not? Whichever way you feel, that's a pretty important decision, so they felt like they should take that one right away. It's a positive if the case cleanly presents just a legal question, all the facts are resolved. It's just a question of yes, no, okay. You know, for example, in Obergefell, the Supreme Court took the case, and the question was, okay, so these marriages between people who are the same sex, is that allowed or not allowed? Does the Constitution require that or not require that? Yes, no. Very simple. Okay. If the case has, messy questions, or they look at it and they go, the facts could go the other way, then they don't like to take those cases, and rightfully so. It's a lot of effort and no result. Okay. Or if the appeals courts are all answering it the same way, the Supreme Court looks at it and goes, you guys are getting it right. Why do we have to step in? So the answer to your question is yes, it will probably be a while before we have a final answer. But sometimes the trend is very clear and there is no final answer. An example of that is, you probably don't remember the Betamax case, but a long time ago, Universal Studios sued Sony, and they said, you're making this device that allows people to record our television shows, and that's illegal. All right. And this case, found its way up through the court system. First the trial court had an answer, and the appeals court got it. And the Supreme Court decided to take this case, and they said, no, that is fine for somebody to do. Too bad, Universal Studios, you're stuck with this one. And since then, the trend has been very, it's been very much the case that, okay, so I can use video recordings. I can take television shows. I can make non-tape digital television shows. I can go ahead and do that. It's now effectively that's a law. you know, the Supreme Court could go back and change the law. They're not bound by the earlier decisions. Congress is not bound by the earlier decisions. Congress could say, you know, that's a great decision you wrote there about what the law is, we've decided to change it. And they've done that. That has happened quite a few times. But the answer to your question is yes, that's right. It will be a while before there's any finality in this. And almost certainly the technology will change before there is. Long use studies, very studies. Okay. Let's go on. All right. Well, we've done a lot of talk about patents and copyright, and patents, trademarks, and copyrights. Essentially, what we need to remember is that there are different kinds of legal issues or different kinds of things. Patents are related to invention. All right. Trademarks are related to your marketing. So, do I market a product? If I, you know, were to market a product and call it, you know, purple Coca-Cola, the Coca-Cola company would come down on me, price, right? And of course, would roughly say, yeah, they're right, don't do that. Okay. On the other hand, if I were to sell a fizzy soft drink and were to call it, you know, Dr. Pepper instead of Coca-Cola, I would be fine. Of course, in this case, it's Dr. Pepper, like not like me, but you get the idea. It's not the same name. It's not too easily confused. Again, similarly with inventions can relate to hardware, they can relate to software, they can relate to a process. Like I do blah, and then I do blah, and then I do blah, and I get a result. Isn't that useful? And the answer, yes, that's patent, right? Okay. Another way startups mess up, and this is my least favorite way, is startups have sloppy agreements, right? Everyone knows, everyone in business knows that you should have contracts. And it's often the case that people mess it up. The first and worst way to have a sloppy agreement is to have a handshake agreement. Now, I know almost everybody is trustworthy. And particularly, we live in a high trust society, which I love being in. I'd rather live in a high trust society than not. And, you know, nine times out of 10, 95 times out of 100, if I shake hands with somebody and say, we'll do X, and they go, yes, that happens. No problem. All right. But once in a while, it does not work. The way it does not work is the agreement's not written down, or it's fuzzy. Or the guy says later, I don't remember agreeing to that. All right. Sometimes you really don't remember, or sometimes I don't remember properly either. Okay. Or, you know, you have a handshake agreement with a company, and you know the manager that you agreed with gets replaced, and the new manager doesn't remember. Or the new manager decides it's not a good idea anymore, and he doesn't feel like he's obligated. Or the company deletes that entire department, and then when you come calling, they say, "Who are you?" Right? That happens. I have seen cases where the new manager who replaced the old manager was not a trustworthy guy. And later what happened was that there was a dispute because the new manager felt no obligation whatsoever to do what his predecessor had agreed to. Well, that led to a lawsuit, much to the chagrin of the company that had hired the new manager. So if it's an important agreement, for God's sake, get it in writing. Even if it's an informal, you know, we agree that we will sell you this stuff and it won't cost you more than blah, or, you know, it'll cost you whatever it costs us plus 25% or whatever, you know, get something written down. At a minimum, get it written down and have an agreement. Another way people have sloppy contracts. Okay. Google is not your lawyer. Okay. Wait. Google is not your lawyer. What?
What did you?
I'll get back to that. Google is not your lawyer. Grok is not your lawyer. Claude is not your lawyer. ChatGPT is not your lawyer. LegalZoom is not your lawyer. If you don't know what LegalZoom is, there are websites that will offer you the opportunity to download for a small fee a contract, an employment contract with your latest employer, or a non-disclosure agreement with your latest contractor. These guys are great. They give you a wonderful first draft. By the way, I find that chatbots are wonderful for generating first drafts. They save me a lot of time. don't use the first draft, it's the last draft. All right, yes. Yeah, the first draft is not the last draft. Invariably, it has problems. And because you are starting a startup and you're a technical guy and you don't have experience in this and law is kind of messy and complicated, and even if you know it, it changes from time to time, you will find that the first draft that you get is a horrible draft for your particular circumstances. You know, if you download an employment agreement and it says this is what you have to sign when you hire a marketing manager and you use it for your chief technical officer, that is probably a mistake. And yet people do it all the time. And this is one thing that will bite you. Again, people might be very reasonable about it. You know, 3 years down the line, you go to your chief technical officer and you go, we signed this agreement, it was for a marketing manager, and we're sorry about that. We want to change section 6. And because our new lawyers who we hired decided that section 6 needs to be like this. And he looks at it and goes, actually, that's kind of reasonable. Fine. 9 times out of 10, that's true. 1 time out of 10, big bump in the road. Don't do that. Right? Get somebody to look at it. Even if it's just, please take a look, see, spend a half an hour, be done with it. Right? It'll feel expensive, but that is the cheapest money you ever spent. Why is it cheap money? Because it's money that avoids big troubles later. Like I said before, it costs you $100 today to get something fixed. It'll cost you $1,000 to fix it a couple of years from now, and $10,000 to fix it if you're in litigation. Maybe $100,000. Let me back up. There are certain contract terms that you really need to make sure are there. People often don't know what they are. I mean, even lawyers don't know what they are some of the time. You know, it depends on the industry. It depends on what's being agreed to. There may be business reasons why this term should be there or not there. You really need to have somebody look at it for real. Sometimes the contract gets written, the term is not there. You know, sloppy results. You know, sloppy contracts lead to sloppy results, and sloppy results sometimes lead to trouble. And sometimes trouble is very, very expensive. Okay? And what I'm saying over and over and over again is, if you have a startup, very, very expensive will be the death of the company. You don't want that. Okay, my clause here on working with Walmart is interesting. If you're dealing with a big company and they send you a form and they say, we're a good company and we don't need you, sign here, okay, then a good fraction of the time you will have to look at that and go, I guess I'll sign. Because, I mean, if you're, for example, you know, if you're selling plush toys to Walmart and they send you an agreement that says you'll deliver however many plush toys we want, whenever we want, on time schedules that we want, and we will pay you $10 per plush toy. And you're sitting there, and it costs you $3 to make them, you're signing. Trust me. Okay? Why? Because you're never going to change their minds, and it's really, really worth it. As much as they may be a pain to deal with. The problem is, and this is working with Walmart as my term for working with people who don't need to change their minds, and it's too valuable to say no. Okay? Watch out for that. Okay? I'm going to come to the end of this in only a little while. Another way startups fail is what I call trade secret follies. Okay? People don't really know what trade secrets are, but certainly every company that starts up, every company, even non-startup, have some things that they do that they care about that they don't want published or people copying just because. All right. If I'm making new software to sell seashells on the seashore and I don't want people to know what my design constraints were or how I'm building the software, or maybe not even what language I'm coding the software in, or what libraries I'm using. And I don't want people to know this. Well, if I want that to remain my property, I need to have policies in place that my employees and coders know. I need to have, I need to have agreements with my people that say, yes, you'll keep this confidential. I need to have behavior that I engage in that actually does keep it confidential. If I keep my code in a private repo, it's better than if I keep my code, at a web page that anyone can access. Does everyone see the difference? The difference is between things that I treat seriously as if they really are secret and things that I don't. Yes.
this has become very frustrating for entrepreneurs.
Yeah.
Because we develop source code for years or months.
Right.
And then one of the partners just feeds into an LLM to ask for some
Oh, good lord.
question.
Yeah,
And you always know this after that already.
after it's too late, right?
Yeah,
This is
correct.
like when you go to your doctor and you say, well, I asked Google and and it says that I have, upper limbitis, and the doctor looks at you and goes, you ask Google for medical advice and you're coming to me. The same problem happens here.
Yeah, and trade secret, if it is an employee, maybe you could even do something legal but if it's a partner,
If you're contracting with them or they're a strategic partner or
no, or a partner, partially owns the company.
partially owns the company, or, possibly you're a not wholly owned subsidiary of that company. Yeah, you could have a problem. And particularly with LLMs these days, which an awful lot of stuff gets fed into LLMs that really ought to be maintained quiet, right? At a minimum, what I am told is that you ought to have the enterprise version of the LLM where they promise to not copy it.
They promise.
They promise. Yes, I know. They could be honest. It's not a perfect world. Better to have the promise than not to have the promise.
If you need to audit that, they're gonna send you a file that is tens of gigs of files. So the trace of the LLM to actually prove that whatever you fed there and shouldn't be used for others is tens of gigs of bytes. It's impossible to.
You're never going to look at it, right?
Yeah, it's like you.
This is like having your customer agreement be 300 pages long, so they don't read it. That's absolutely correct. It's a problem. We are going to see more of this in the LLM world. As a general rule, what I would say is, first of all, don't use the public version. Use the version you paid for, the one where they promise not to make it, not to use your data. If you can use find the version that allows you to run it on your own machine without telling anyone what you're doing. There are versions like that. Certainly as a first draft, you can use that. And if that's not good enough, it's not good enough, you can go further. Do something about it. Part of trade secret policies is where the information is stored, how it gets accessed, who gets to access it, what they get to do with it when they access it. All this information, everybody knows this is a ordinary good business practice. If you don't do this, you're making a big mistake. Not because someone is going to come in, corporate espionage or work out of there, but because when you later try to enforce that agreement, you will be stuck. That's a big bump. Certainly, that's a problem, and we don't want that to be a problem. Part of this, almost everything I'm saying is don't do X because it might be a problem later, and when it is a problem, it'll be very, very, very expensive. We don't want that, right? I love getting calls from people, but I don't love getting calls from people where I have to say that will cost you more than you really want to spend just to fix it. Similarly, the way you treat customer data is going to matter. There are a number of states. Texas is one of them. California is one of them. Illinois is one of them. More of them are jumping in the bandwagon. There are foreign countries. There is Europe has the GDPR, General Data Protection Regulation. It also has a European privacy rule, which they have recently enacted. There's also the European AI Act, which will make a difference as to how you treat customer data. This is one of those things where, okay, if you do it right, it's a pain in the neck. But if you do it wrong, eventually you'll get a call from a regulator, which will rip you to shreds. You don't want that, right? One of the things I frequently tell people is, you do business on the internet, you're doing business everywhere in the world, literally every foreign country in the world, and every state in the United States has a hold on you. Do be careful. This is one of the cases where looking ahead of time, as with many cases, deciding ahead of time what risks to take and what risks not to take is much, much better than finding out later what they were and we didn't know. End user agreements. Similarly, what your end user agrees to is going to matter as to what kind of service you provide to them. If you're running a social media platform and you don't have an end user agreement, boy, you're making a mistake. If you are running any kind of user service, and your end user agreement is going to help you, or not having one, or having a sloppy one will hurt you because of the way your end users will behave. And almost guaranteed there will be somebody who will test you out. Non-disclosure agreements. Naturally, if you want to keep company secrets, you will need to tell them to somebody to help you out. You will need to make these people agree that they will not broadcast this to the New York Times or to your competitors or that sort of thing. You want that arranged. You want to make sure that those are all signed, and you want to keep records. And then there is privacy law. And as I mentioned with respect to customer data, everyone is jumping on the bandwagon of customer privacy. If you offer any kind of service where you care about customer data and you maintain anything, even if it's something silly like, you know, I have a program that teaches you a foreign language and I keep a record of your progress, do be careful, because this could turn into a major headache later if you have not paid attention ahead of time. Again, this is a little, remember what I said about decisions that are reversible versus decisions that are not reversible? Once you send something out into the grand old world and people are latching onto it and using it, that might be an irreversible decision. You do want to be careful about that kind of decision before stepping into it. Test beds, you know, experiments, things where people sign on and they get to, and you have convinced them to agree that yes, this might or might not work, and you know, whatever you do because you're testing it out, and they agree to that, and everything is fine and wonderful. That's reversible. Stuff that you do on a commercial basis, that's a lot harder. I guess that must be really clear. Everybody knows. We've all signed the Facebook agreement, yes? How about him first? And then you have a new person.
So what about like the privacy law? What if you use like cookies or like local storage to store the progress, and like the privacy doesn't really apply because you never actually get that information yourself, right?
Not quite true. I know that the European rules require that you get consent for the cookies, and I'm serious. And it may turn out that, you know, some state law may require that as well. There's also certain kinds of data that even if you store it.
Wait, so local storage would require consent because it's not a cookie, right?
We have that in Germany, and we have we could find that because it was your policies.
So local storage is
Yes,
cookie?
yes, and my company will be paid like that.
Okay. And maybe it's more accurate to say cookies on local storage.
Yes,
Right.
because the policy says everything that is stored needs to be fed on to the user, and then in this.
Well, but I think the difference is that cookies actually get sent to the server. The local storage is normally like it's local, so it doesn't actually get
It
sent to the
doesn't,
server.
as long as they say, as long as we use that data to their data without their consent, it's basically.
Well, if you don't have that data, like the user has that data, so you never actually get that data.
About we using that data.
Let's just back up a second. From a broad perspective here, the broad perspective is that there are going to be rules that you must follow with respect to customer data. And maybe the rules say, yeah, if you never look at it, then you're okay. Maybe the rules say, no, if you can look at it, you're okay, you're not okay. Maybe the rules say, only if you don't aggregate it, you're okay. I know there are a lot of people who say, oh, we don't keep your data, we only aggregate it. But the reality is that aggregatable data can often be disaggregated, and you could have a problem with that. And unfortunately, privacy law is still in what I would think of as the wild, wild west. It depends very much on what does California have to say, what does Texas have to say, what does Florida have to say. These rules are different. Illinois has a rule about biometric data, which I am not sure is subject to any of these restrictions. So the big warning here is whatever you're doing, I mean, at least have open eyes and know what risks are you taking. You know, maybe you feel that this is all perfectly hunky-dory and you're welcome to do it. And if that's true, and you know, later some regulator says you were not right, well, you know, you might be able to claim that you were, you know, that you were innocent, or it was a mistake, or you know, you did it on advice of counsel and it was just fine.
Does that excuse works?
What?
That excuse works like I did it on the advice of counsel.
Only sometimes. Only sometimes.
I just wanted to, because once worked at a company where I was the one who told them this, and they didn't know it until I told them. So it was a case where they didn't realize that a credit card number transiently going through their server
Oh, good Lord.
mattered.
Yeah.
They thought if we don't store it, but it just transiently goes through our server, then it doesn't matter. And I was the one who had to tell them, no, there's a bunch of rules and you. So I just thought I'd bring that up because I thought everyone knew that, but no one in the company knew that before I told them. So there's.
I don't expect people who are building new products to know everything about what the risks involved, especially the legal risks involved, or for the new product. And if your new product receives a credit card number and ships it immediately off to a credit card processor and deletes it afterwards, that may be wonderful in terms of security, and there might be a regulation that says no, don't do that. All right, and it depends. And in this case, apparently it was.
And the credit card companies don't like that. They want it to happen a different way where it doesn't even transiently go through their server.
I'm sure they don't want you to know the credit card company,
Yeah,
credit
they
card
want
number
the
either.
customer and a credit card company to talk. And so there's a protocol to do that, and you don't have to invent it, but you have to know, no, I can't even put it on my server, even have it show up transiently. So,
I ran into a similar problem this very day, where we're setting up to try to take credit cards, and our credit card provider is asking us questions like, well, does any other credit card provider have this information? And I'm sitting here going, well, no, and why do you need to know that? And we need to know. Is this credit card tied to any other account in the world? Oh, no, we need to know. You do, huh? Okay. And yet they do. And the problem is worse for me. I have other regulations I have to deal with, not just credit cards.
Also, on the biometrics thing, I know that it is different. Texas has some requirements on biometrics that are not the same as other states.
Illinois has some requirements that are very strict.
Yeah.
Texas has different requirements. California has different requirements. Various states have different requirements, and various foreign countries have different requirements. If you ever do business with those foreign countries. And by the way, some of those requirements are a resident of our foreign country, a German resident does blah, 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 you have to do this. And it doesn't matter if he's sitting in Canada when he does it, which could be a real problem because you can't just fence off and say, we won't take requests from there. And you end up with problems. Yes.
Yeah, I wanted to just high level discuss robotics data in particular, like this is going to be like video and audio data. If you have a home robot company, the robot goes to someone's home, it does things for the home, but you're also going to learn from that data. So you might store it and train machine learning models to get your robot to perform better. Maybe you create a coffee shop robot, so the robot can go to a coffee shop and learns how to make coffee. You're using that data to train the robot on a continual basis. That's in public space, private space,
I smell trouble.
what kind of laws are we now getting subjected to?
Well, certainly with respect to somebody's private home, you could have a serious problem with privacy law. I mean, for example, I know California's privacy law will apply to information that you gather about what their daily use is like, what the size of their apartment or their house is, how frequently they use this cleaning robot. And if you have a Roomba that runs around the house and just keeps the floor clean, that's going to count.
But the size of public information, right? The size of the house.
Just because it's public information doesn't mean it's used to get. Okay.
And if it's inside the house, then they're non-public.
I'm really serious. It could be publicly accessible, but you're not supposed to store it. Read the statute. Okay, and there are regulations that go with the statute.
This can all be mitigated, I assume, in user agreements that with, the robot is predicated on
Yes
the fact
and no.
that we can.
Yes and no. I mean, some of it can be mitigated with user agreements, but for example, if the state of, Florida requires that you delete the user's data upon request within 3 days, you better have a way to do that. Okay. If the state of California demands that the user gets and asks you for a copy of all the data that you keep about him, and you have to give it to him, you better be able to do that. Writing back and saying, we're sorry, we don't know what you're talking about, is probably not going to help in those circumstances. I don't know for sure.
Yeah.
Okay, because it's very fact dependent. But the reality is that these rules are being written, and some of these rules as written are onerous, and some of these rules as written make no sense, but they're still the rules.
So if a robotics company was thinking about deploying the robot, they might want to just stick to a single state for a period of time to avoid the
You
state
might.
by state by state by state.
Yeah, you might. It depends. It may turn out that this state is easy to deal with, and they can become hard to deal with tomorrow. I mean, let's suppose that you decide that you're going to be just fine with working with Georgia, and because they don't have any rules on this, and then 3 months from now, the Georgia legislature goes off and enacts a rule and says do X, Y, Z, right? Or maybe you decide that you're just fine with doing this, with, let's say, California, because they have a $25 million business minimum before the rule applies to you. And then, you go 1 quarter from 25 to $30 million, and you go, whoa, 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 and you break out the champagne, and the lawyer tells you that means X, Y, Z, W has to be done. And that could be an issue. Yes, I actually saw you back there.
When you mentioned, laws about having to provide all of the data gathered about a user upon request, that made me think about the local storage and cookie thing. So there's some cases where me as somebody who has access to the database, I can't necessarily, I can't pull data off of people's computers. So, I mean, you probably don't know, but I'm just curious if that's come up, like data stored on their computer or in cookies or local storage or whatever. Is that subject to those kinds of things, or did the legislature just not bother caring about those details?
1, I don't know. And 2, even if the legislature did not care about those details, the legislature may have handed off regulation to an agency which has decided to care about those details. So the answer might be no today and yes tomorrow. That's unfortunate. I can't, laws change.
So as far as I know with cookies, in Europe, you have to consent to store cookies in. So what people have been doing is filtering the IP address, and if it's an IP. So if you navigate on a VPN in Europe, you're going to see some of the websites are used to asking for consent, and if you navigate from America, they will. So it's consent, it's not even the storage. So there's the GDPR, but then there's all the legislation.
Well, that's because their rule says you must obtain consent.
Consent, yeah.
And their rule says obtain consent, and the way they obtain consent is they pop up a message that says, please check yes or no.
I guess my question was more of, if, say there's a law that says when the user requests, on request, you have to provide all data that's been collected. If data is,
So it's California's policy, yes.
if data has been collected, if data that is in their browser exclusively and not on the company's servers, if that data, local data counts as data that has been collected, I don't have any way of capturing that.
Exactly, we collect it, even if you are not the client.
Sure. My
And
point
this
is,
is how
if
we
the
get the
user
client.
says- if the user emails me at support@whatever.com, I can't necessarily, I can't reach out to their computer and grab it.
Okay.
You probably give them a web page that will show them.
Exactly, you know.
The answer is partly, I don't know the answer yet, and partly it's going to depend very much on facts. And partly it's going to depend very much on what does the statute literally say. Does it literally say the information you're storing on their behalf, or does it literally say information you have about them and then it's readily accessible, or does it literally say something else? And knowing the way these rules get written, it's going to say something else which is totally okay. Welcome to my world. Yes, direct question.
I think it was about.
If it got covered, that's okay. We'll come back and you'll have plenty of chances. This is supposed to be an interactive discussion. Okay. Anyway, we've talked about trade secrets. We talked a little bit about the care and feeding of trade secrets, which mostly has to do with keep them secret. Make sure you check with people as to what they're keeping on your behalf. Keep a record. Okay. Privacy law. We just talked a little bit about privacy law. Warning: the European laws are painful. Okay. And anyway, the bonus round. Okay. Yes. Before I get to the bonus.
I have a poorly formed question.
Those are the best kinds, because I can blather about them and you never know if I answered it or not.
There are a lot of countries that it is now legally fraught to do business with. Do you like Iran?
Do you mean like Russia because there are American
Russia,
sanctions on there?
Yeah.
Or do you mean like it's legally fraught to do business with,
Well, I think Texas is one of them. Like, there's a lot of websites that are like blocked in Texas now.
oh, you're thinking of Pornhub and their,
Yeah.
and their
I
affiliates.
was thinking of things like Iran and Russia and so forth, where
Well,
your
right.
company's not supposed to do business. I was wondering, is there any standard of how much effort you have to make to figure out if your customer is in Iran, like if they're using a VPN to try to block where they're from or something? Is there any?
So Russia doesn't actually have like monthly restrictions. Like, the restrictions are only like in the disputed
I know
parts. So, like,
restrictions in America
No, no, no,
about
no.
doing business with certain companies?
yes, so there's no restrictions like for all Russia. There's only restriction for
Right,
like certain.
But there are
parts of Russia.
companies like Rosneft within Russia that you're not supposed to
Let's back off a bit on this question because it's going to be fact intensive. But very broadly speaking, if you do business on the internet, you do business everywhere. Okay. And if Saudi Arabia decides that you can't offer
alcohol.
abortion services, okay, alcohol, all right, pick something that they might not like, okay, what? Like,
Women.
like, you can't offer women here either,
Most things.
Yeah, Nevada accepted. All right, that's it.
That would be difficult to do. Anyway, go.
Anyway, you're subject to the rules everywhere. If you are trying to avoid being subject to those rules, you are going to have to do some work. Okay, if it turns out that country X decides that you shouldn't be offering alcohol and you are offering alcohol, then you're going to have to be able to demonstrate to the satisfaction of country X that you weren't offering it to anybody there. Right? And if they're not satisfied, then you're going to have a problem. And maybe your problem is solvable by going to an American court and say, please tell these guys they can't do anything to me. Which, by the way, I saw a lawsuit about that was filed, I think, in August of this year. Maybe it was June. About exactly that problem. Some American company complained about the way British regulators are treating them. Yes,
What
yes,
company?
really. What?
What company was it?
Fortune.
Yeah. And Apple.
No, not Apple. It was,
That was a recent one.
that's a different issue.
I asked for a backdoor, right? Yeah.
Oh, yeah, that's a different issue. Yeah,
How did that go? Fortune.
we don't know yet. They filed the complaint. They served it. District court has not ruled on it yet.
So which form? So what happens?
It's been filed in district court in the United States.
Wait, so who did this?
Yeah, trial court in the United States. Oh, which district is it? I think it's DC.
Who did they sue? Like,
They sued the UK Office of Communications Regulation.
in US
Also known
court?
as Ofcom, in US court.
Also, they sued Ofcom. Wait,
Yeah.
but like Ofcom, it's effectively like British government. So like, how can they sue British government in the US court?
Open to some debate now, isn't it?
Ofcom,
Okay.
just for record, Ofcom stayed 8 years without without a major director. Was headless for 8 years and it has a head now for 2 years.
Okay, well, partially the answer is it really part of the British government? In theory, they're an independent corporation, but they have been granted the right to do certain things, which sure look to me like governmental behavior. But then again, if the British government disclaims that they're part of the government, then the United States has a rule called the Foreign Sovereign Immunities Act, which may or may not apply. If it does not apply, it might fail to apply because the First Amendment may trump the Foreign Sovereign Immunities Act, or there may be some other reason. And naturally, this is to me, this is unsettled. I know I have not looked at it carefully, but I do know that this is a perfect example of you do business on the internet, and everyone and their brother has the ability to cause you grief. And this is a perfect case of you do business on the internet, the British government, I see your hand, I'll get to you in a second. The British government may or may not come down on you, all right, and may or may not be able to because an American court might refuse to enforce whatever the British government wants to do. Yes.
Wait, so did Ofcom, did they hire like legal counsel in the US or what is their plan there?
I'm not clear what Ofcom's plan is. My guess is that, that Ofcom will eventually be told to answer the complaint. And they may have to answer the complaint. Well, if they have to answer the complaint, they're very likely to have to hire American counsel.
Well, they could just default, right? No.
Sure, if they want to,
They will most probably go back.
maybe. We'll see.
Market on
What? Yeah,
the prediction market.
we go to,
Right?
go to Polymarket and see what they have to say.
Except the fact that very few people.
So the Ofcom,
Ofcom with an M.
did they like impose a fine, unfortunately, is that what's happening?
No, what happened was Ofcom sent some information requests to 4chan. They sent an information request to 4chan, which and 4chan said, roughly, we're not answering this.
Yeah.
And then they sent another one to 4chan, and 4chan said, we're not answering this either. And then they wrote a letter to 4chan and they said, well, we're going to impose a decision against you if you don't answer, if you don't give us what we want.
Lock your site.
Who knows what their decision is going, what they can do. They can, anyway, so Ofcom threatened 4chan with legal consequences. And 4chan, after a while, wrote back and said, we're American lawyers and we say we don't have to do this. And Ofcom said, we say you do have to do this. And eventually 4chan said, well, that's just great. We're going to court. And they did. All right. And there is a very, very, very funny declaration from a process server in London saying, I tried to start Ofcom with this lawsuit and they locked the doors and pretended they weren't there.
So they reduced getting served?
They tried, but didn't.
Somebody eventually, it's like, see Sam off.
Yes.
Served.
So it's Ofcom, like, it sounds like a Federal Reserve, like it's not like part of the government, but it's still like a private entity.
It's really, from an American perspective, it's an independent agency. But the British way of doing this is that they are apparently a corporation which has been granted by the British Parliament the right to do a certain list of things they have a right to do, one of which is effectively making people pay them fees, and one of which is, making people answer questions. And 4chan basically said, you had a dispute with these guys back in 1776, and we decided that we like it on our side of the pond.
Charter.
Yes.
I just had a comment, I don't know if people know this, but like RT, for example, and like CGTN, like the Chinese television, they're actually regulated by Ofcom, but BBC World Service is expressly not regulated by Ofcom. So
That's very nice for BBC World Service.
Yeah.
Yeah.
So, just, you're talking about doing business in Saudi Arabia and all that. So I'm just curious, if I was running a website, and let's say pure digital, not physical products or anything. If I knowingly or unknowingly let somebody from Saudi Arabia do something like maybe pay for a service or maybe it's a free thing that Saudi Arabia says is illegal, how much trouble am I in as a U.S. company just in the U.S., not incorporated?
Realistically speaking, or, or legally speaking, I have no idea what Saudi Arabia's laws are, and I don't plan to.
I guess it's more of, if I'm a company and I'm only doing, and I'm based in the US, I'm only accepting payment from US or from US bank accounts.
It may or may not be restricted to payment. For example,
But I mean, if some other country gets upset because I did a thing on the internet.
realistically, they're never going to be able to arrest you in the United States, but unless they turn out to be somebody that we really care about, like say Canada. And you've done something that we think is really bad, like, say we've defamed people and we've got defamation laws ourselves. Like, you libeled somebody and they come out and they come to court and they say, so and so, John Smith libeled me and here's what he said about me. He said I was, he said that I robbed a bank yesterday. That's clearly not true, and here I'm suing. Okay, well, an American court would give that credence. We would say, okay, fine. Yes, Canadian court can resolve that. Come get it. Come here and complain about it, and we'll look at that too. All right. On the other hand, if, for example, the government of Thailand comes to the United States and says, you slandered the king, that's illegal. An American court will go pound sand. We don't care if he slanders the king. In fact, good for him, okay, which is American law, and First Amendment protects you. But it wouldn't protect any sign, so I mean, if you book the tickets, you sure you know where you're going.
You should have a layover.
Yeah, the layover.
And if you do have a layover time, bring your people. Bonus round, not calling the words. One of the things I often tell people is, look, I get it. Lawyers are expensive. I'm not cheap. Okay. But we're a lot more expensive when we're fixing trouble than when we're preventing. Okay. And a good lawyer will know that his job is not to give you a legal answer. His job is to promote your business. You want your business to succeed. I can't make it succeed, but I can tell you what you can do wrong and it will fail. And we don't want that. So, if you go early and you say, blah, 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 we're doing this, and your lawyer says, oh, don't do X of what you're doing. Okay. That is the cheapest money you've ever spent, because it will save you 10 or 100 times as much down the road if it turns into a problem. Now, yeah, I've admitted and I've told you that most problems don't become serious problems. You know, as Calvin Coolidge once said, and remember who he is, he was once president. If you see 10 problems coming down the road, 9 of them will be gone by the time they get to you. True. Okay? But the one that does get to you might be a real serious problem. If you knew enough to avoid it, you would. Right? This is why you want to see your lawyer earlier. Not because you want to go and sleep well at night or you want your lawyer to send speaks to college. It's because you want to avoid things that could turn into a problem, which is not just a problem, but a death sentence for your startup. And this is one of the biggest things that people do wrong. Don't do that. Please. I love giving people advice that says you screwed up. It's not my favorite advice. Even when it's true. Okay. This is me. This QR code should go either to my LinkedIn account, which I will be very happy to give people, or to my sign up and talk to me for half an hour account, where I will also be very happy to talk to people, but in case two, we'll talk to me. Not a whole lot. As my daughter says, less than a dress.
It's like it's your like
Abercrombie.
What kind of dress?
What?
What kind of dress?
One from anthropology. She said that specifically.
No, what is
I
your
asked. What?
It's your LinkedIn.
Oh, good. All right.
The
And feel
previous one
free
was
to.
calendar.
What?
The previous one was calendar.
Previous one? You mean this one? Okay, you look. Good. I'll keep that in mind.
But it's a calendar for September.
That's because
It's in the past.
maybe that's because it's not properly looked at. But I mean, if you schedule time, it will schedule time for you, and it will charge your credit card.
Oh, okay.
Okay.
For September?
What?
For September?
No. It's for September, or not October either. Only if it's September next year. And if anybody wants to talk to me afterward or give me a phone call, 5 minutes, feel free. I'm here. I want people to succeed.
Well, thank you very much.
Thank you so much. Thank you.
Hi.
Hi.
Your Ralka, nice to meet you. Your email address is very hard to write in order to connect you with you on LinkedIn, so I will